Division 1 is now in session.
Thank you. You may be seated. Good morning. So we are here today on our case number 1CACV170243, SHAFER versus WALGREEN Arizona Drug Company. Each side is allotted 20 minutes, as you know, for the argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have, including what you might have decided to reserve. We record these proceedings, so we'd be grateful for you. We'd be grateful if you both would, when you approach the podium, give us your name and the name of your client for the recording. We've reviewed the briefs and the record on summary judgment, and we've also discussed the case in our conference this morning. So with that, you may proceed.
Thank you, Your Honors. My name is Donald Smith, real name, and I represent Kathleen SHAFER, the appellant in this case. I know it's my responsibility, but I'm going to attempt to reserve 3 minutes for the rebuttal at the end. Your Honor, this case, as the court is well aware, is really a case of whether the method of operation claim applies to Ms. SHAFER and Walgreens. In understanding this, we need to understand that Walgreens today, and at this time, was a different Walgreens than, say, 30 years ago when Walgreens was a pharmacy. We are not really talking about a pharmacy issue here. We're talking about a business that has chosen in its mode of operation to become what's basically the local convenience store for neighborhoods. As we all know, there's Walgreens everywhere. In doing that, they have actually become the convenience store for the neighborhood. In doing so, they have actually opened up and sell sodas, air fresheners, which is what we're dealing with in this case, and other products. And they opened themselves up to the risk of doing that. In this case, we have a case in which Ms. SHAFER went there for the purpose of buying air freshener and some other products from her deposition she testified to. And in looking at a product, she picks it up and it falls out of the bottom that was open and injures her, as the court knows. During discovery, we learned that the store manager and 2 longtime employees, which was very difficult to get their depositions, but when we finally got them, we discovered that opening of products they testified to was a daily substantial problem. People open them at the top and people open them at the bottom and put them back on the shelves.
But is it a problem that causes injuries to customers?
And, well, that was their testimony, was that they understood, the manager said that he understood that caused a risk of injury to people, that they understood that could cause a substantial risk of injury. And that was the testimony of the assistant manager.
Was there any evidence that had ever happened?
There's no evidence that it ever happened. The method of operation does not say that you have to have somebody injured and that's part of what I think the problem with the trial court's ruling was. Under the trial court's ruling was that basically they'd have to know that a soda can can fall. They'd have to know that an air freshener can fall. They'd have to know that whatever, each item could fall.
But it does require that you reasonably anticipate that a hazardous condition will regularly arise, is the language that the case
Absolutely.
is used. So don't you have to show that this has happened more than once or is likely to happen more than once? Your judge quoted the case very specifically. You have to know that a hazardous condition will regularly occur.
How do you know if it's hazardous if it never causes an injury?
They testified that they knew it was a risk to their own people. They testified that they knew that this was a risk to injury.
Did they testify that it regularly arises?
Every day.
But that a hazardous condition regularly arises?
Yes. Every day they testified that they know that this condition, the one employee of 17 years says this was a substantial problem at this store, at this particular Walgreens.
Did he did he say the issue of opened packages was a substantial problem, that people were opening the packages and
Yes,
putting them
that
back?
there was a substantial problem and that they knew that was a risk, that those open packages were a risk. And
Well, it's a risk, but that doesn't mean that it regularly, that the hazardous condition regularly arises. It's a risk that the box is open, and you can say in the abstract, sure, anytime there's an open box, it may be problematic. But I'm having a problem with the hazardous conditions will regularly arise.
well, let's break that down into parts. Is there a condition that regularly, I'm going to break it down and go backwards. Is it, not hit the microphone again.
It happens.
Does the condition regularly occur? Yes, every day. And when we ask
But the
them,
box sitting on the shelf by itself opened isn't necessarily a
but when you
hazardous.
I knew I was going to do it again. When you put it out on the shelf, you put it out with the intent that people will pick it up. If they pick it up and it's open on the bottom, there's a risk that it will fall, and that's a hazardous material. So if it occurs every day, you need to do something to address that issue. And here, we aren't debating as did they check it every hour, did they check it every 2 hours, they did nothing.
I think the briefing says that they check or they look
At
once
closing.
At closing. But so are you suggesting that they should do it every hour? They need to go around and.
Well, interestingly enough, they have 3 parts of the store that they pay attention to. One, the pharmacy, obviously. One, the camera area, and the other one's the checkout area. They keep cameras on to see if anyone's messing with things at those locations. They don't check any other areas unless by pure happenstance. Here, the case is that this object was placed back.
But are they checking those areas for hazardous conditions? It sounds like those are other reasons for having.
Well,
checking
they're actually
cash
doing
registers.
it. The pharmacy, I think they're required to by federal law. I think you need to video the pharmacy for a different reason. The camera at the front, the one at the front is obviously, like any convenience store, you film the front in case you get robbed for security reason. And I never have quite ever understood why they filmed the video, and the manager didn't really understand that either, but the photographic area. But back to what we were talking about before, they clearly knew that this was the case. They clearly knew when a package was opened. It's undisputed. They testified. They clearly knew when a package was opened, it created a hazard to the public, to the people they invited in to do
What's
the
the
business.
closest case that you've seen? The ones that I'm recalling, and it's been a few days since I looked at them, but where it's in an area of the store where there tends to be things seem to happen on a regular basis, and you should expect that you're going to have a problem there. Is there a case that's close to
The
this
closest one I think that was least discussed was the one that dealt with the cream rinse.
It's on the floor.
Yeah, because that's an open product case. I think that's why it's closer, because it's an open product. The question becomes one of, in all these cases, the question becomes one of foreseeability, which I think is what the court's talking about here. Is it foreseeable somebody could get injured? And here, their own testimony is they knew it was foreseeable somebody could get injured because they knew it was a risk. And they knew it was a substantial risk to other people. And I think the problem here is they did nothing about that.
How would they know it's a substantial risk if something's never happened before?
That's what they testified to.
But that just seems to be sort of in the abstract that, sure, if something falls, if I were asked that question, I would say, yeah, there's a risk it could hurt somebody. But we can't expect stores to go and inspect every shelf every 20 minutes. It seems like it's reasonably anticipate that a hazardous condition will regularly arise. Seems different than in the abstract, it could be dangerous if something drops out of the bottom of a box.
Well, I understand what you're saying, Your Honor, but what you're basically doing then is making everybody goes in that store has to be injured. Somebody has to be injured by each product before they ever have a knowledge that that product could hurt somebody.
Or by one product.
Well, they would argue the other.
Well, they might. What under your view of the rule, the mode of operation rule, and the facts here, what What would the jury be deciding, other than the question of damages in your case?
No.
What would the jury be deciding?
And that's where I was trying to get to, was the fact that it isn't that we might win or lose, that they could convince a jury that this isn't applicable. Just as a matter of law, it shouldn't have been decided by the court. The jury should be looking at this. One, did they know that they had a problem with open packages? First question. Did it occur substantially enough or often enough to be an issue that they address? Were they aware that it caused a risk to them? That's what the jury would do.
That second part, there doesn't seem to be any evidence that this had regularly occurred.
That product, Judge, there's no dispute that they have a problem in that place. That's their own testimony, a substantial problem with opening of packages, top and bottom, both.
Customers just leave them there.
Just
Okay.
leave them there.
So, but did the employee, or the employees asked why they go around every night and fix them all or take them off?
Well, they do the famous bins. You
Yeah,
probably
put 'em
saw
in
this.
bins,
Yeah, they take them down and take them off the shelf for a couple of reasons, as I understood the employees. One is they got to return them because they get a refund for them if they've been open.
And they can't sell them.
They can't sell them. And the other reason was that they needed to take them off in case they were dangerous or in case something was going to happen because they knew they were a risk. But the bin product was the main reason they're taking them off. And to be honest, why somebody opened the bottom of this one has never made any sense to me. And they testify that they open the bottom all the time. I understand somebody might open the top.
About opening it, you don't want it to be seen that you've opened it.
I'm the guy that doesn't eat grapes in the store, so I don't open products unless I buy them. But I mean, I understand. See, I could understand opening the top and smelling something because we're talking about a fragrant,
Yeah.
and closing it back and putting it on the shelf. I guess Your Honor's right. They open it so they won't get caught.
But what would be the jury question on the elements of mode of operation? Go ahead.
I think, if I'm not mistaken, it's actually in the Raji. It'll be there. Did they know just what the other judge said? Did they know that this was frequent? Did they know it was a substantial problem? Did they know it was a risk to their people?
But they also have to decide that hazardous conditions will regularly arise.
And they testified that knowing that this was a hazard to their people and it occurred daily, that they took no action to address it. That's their undisputed testimony, which I'm going to be honest with the court, I was surprised I got. Mm-hmm. I was anticipating when I asked them those questions, we've never heard of this happening. This is the first time it's ever happened. But they were honest.
But they did say that, from what I've gleaned from the briefs, there hasn't been any type of accident involving a product in an open box. So they didn't say that regularly happens.
They have not. Your Honor's
really
correct.
open.
And I don't want to, I'm not trying to fool the court. I really am not. They're not saying someone had something fall out or an open box injured someone. They did not say that. They said, but I don't think this is the old dog bite cases. I don't think the law is. In those other cases you talked about that occurred, they didn't say this had happened before. And you have to. Well,
but doesn't it approach just strict liability for anything that happens?
Not. Absolutely.
But why not if you haven't shown that this has happened before? Because this is really a substitute for the notice requirement. That it's been, you've seen that this has happened on a regular basis. Is kind of the way I was interpreting the mode of operation. The hazardous conditions will regularly arise. So you might not have known that this particular one was going to fail, but these conditions, it's been happening, so you're on notice and you should have done something.
And that's why it's not strict liability. You had to be on notice that a hazardous condition existed and occurred on a regular basis. You had to know that the products were open on a daily basis. You had to know that they caused a risk. Not, in those cases, it had caused a risk to the public. It didn't. None of those cases, I think, say that I remember, say it had to have injured anyone before. It says it had to cause a risk of injury.
And that's why you're calling our attention to the cream rinse case.
Correct.
Where the court said it's insufficient to demonstrate that spills of some kind regularly occur. The business must be able to reasonably anticipate that a condition hazardous to customers will regularly occur.
Right, and that is what occurs here, that the hazardous condition, the opening of products and leaving on the shelf, regularly occurs, and that's the difference here.
Is the difference that you're pointing out between that case that the spills there only happened a couple times a week, but the employees here testified every night? Or is it that no one had slipped and in the rinse?
I think in this case, Judge, it applies to both. It's reasonable to consider for both for this. I don't think there's any magic numbers of when the risk occurs. And I think that's what those cases, to be fair to any premise owner, if something occurs once a week or two, it's all facts that should be considered in the light of the whole thing. Here, this isn't a case of how often this occurs. They said it occurs every day. But now to the other one,
but it seems very different. Sorry to interrupt.
Oh, that's all right, Judge.
On where you've seen liquid on the floor, I mean that's something that I think everybody, jurors would understand. It's dangerous to have liquid on the floor. The store knows that there's liquid on the floor. Here, the store just knows that there's an open box. But it seems very different than we've seen puddles that people are going to slip on. This is just a box that might drop. It might not drop.
Let's take this one. This product. It's a product with a glass container inside of it. It's a problem that when the glass container falls out, you have no time to react. This is what happened to Ms. SHAFER. That's different than a slip and fall. You may be able to see a fluid in the floor. She had no way to avoid this. She had no way to get around this. And the simple fact is that's more dangerous than your fluid on the floor. Because I've done a few slip and fall cases where the fluid was on the floor. And the first thing the defense always says is, well, why didn't you see it? They can't do that to her here. They can't say, why didn't you see it sitting in the floor? This is a glass container that fell. If you go into Walgreens, I almost said Walmart. If you go into Walgreens, you'll find products that are heavy cans, soda cans. You'll find products that I'm using the soda can because it's in a box. And you can pick it up and a whole dozen soda cans falls out on someone. Those are dangerous products. And the store should, if they know that it occurs on a daily basis, and you know by their testimony that runs a risk to someone, the jury should be allowed to weigh that and decide whether that risk should have been addressed if a reasonable owner would have done it. And that's why they shouldn't have been ruled on by the court as they did. One thing, there is a footnote in here. I'm going to shut up unless you have more questions. The one thing, there was a footnote in here that just was thrown in that said there's no evidence that there might be a possibility that Ms. SHAFER opened the product and dropped it on her own foot. There's no evidence to that. This is clearly an issue of the premise liability. And I'll stop unless the court has some other questions.
Thanks.
Good morning, Your Honors, and may it please the Court. Jennifer Anderson for Appley Walgreens. And I think the Court is homing in on the fact that under Walgreens' mode of operation, which is not to do nothing, what it does is once a day, at a minimum once a day, it checks the products on its shelves when it's facing the products, and then throughout the day intermittently as the shelves are stocked. There is no evidence that any opened package has ever created a hazardous condition or posed a hazardous condition before. And I believe that Mr. Smith is overstating the testimony of the Walgreens employees. And I would challenge him to point to anywhere in the record where anyone said that these open packages pose a substantial risk of harm to anyone. Here's the testimony that I think he's referring to, and it's Jim Ammon, who was I believe was a manager. He's asked, isn't it something that can cause a risk to the people shopping if a product has been tampered with? Foreman Foundation objection. Mr. Ammon replied, I guess it could. So he's merely speculating that under some circumstances, possibly, it could create a risk. But under Chiara and Contreras, it's clear that that's not enough. The plaintiff has to show, for example, in this situation, that a product that was heavy or breakable or sharp fell out of its open packaging on a regular basis, because most packages in Walgreens, if they fall out because they've been opened, there's no hazard. If somebody drops cotton balls, that's not going to be a hazard. Somebody drops envelopes, that's not a hazard.
But if someone drops air freshener, a glass container of air freshener, it could hurt someone. What's the best case for the proposition that when courts always talk about the existence of hazardous conditions when they talk about the mode of operation rule. But what Mr. Smith is saying is there's a distinction between he is saying he shouldn't have to prove that the risk has come about before. He's just, all he needs to show to get to the jury is that an acknowledgement that if there's a heavy product in package and packages are regularly opened, and if everyone knows if that falls, it's going to hurt someone or could hurt someone. What's the best case for the distinction, what we mean when we're talking about hazardous conditions?
Well, I think Contreras is the best case. I think Chiara set up the rule and Contreras really fleshed it out.
That's the rinse case.
Contreras is the slimy blue substance case.
Oh, so it might not be
Chiara
cream rinse,
is
it's
the
slimy
cream
blue something.
Yeah,
Okay.
Chiara is the cream rinse case. Okay. And just real quick, when I'm thinking about it, in Chiara you had a store employee who said, basically, we have so many spills, I can't even remember this particular one. It happens all the time. It's not the cleanest store in the world. I always have to clean things up. That is far different from this case, where there is no evidence, no testimony that a product has ever even fallen on the floor, much less injured someone.
In your view, can the mode of operation rule ever apply if there has not been one instance of a particular product falling?
Falling or falling and hurting someone?
Falling and hurting someone.
Well, the mode of operation rule is a substitute for notice. So, what would be reasonable notice to Walgreens? I suppose under some circumstances, if, for example, in the air freshener section, or I don't know, some
or the soda section,
something where there's heavy breakable items on a regular basis. These are falling, through the bottom of their packaging when customers are picking them up. I think it's conceivable that case could get to a jury. That's not this case.
If it happened one time before, the second time, do you get to argue mode of operation? Would that be the rule?
If it was the only time that it had ever fallen, period, and not to mention injure someone, no, I don't think that's enough.
To clarify your prior answer, are you saying that there would not necessarily need to be prior injuries as long as there was perhaps a more extensive history of actual dropping and breaking and
I have this vision
evidence
of people
of-
hopscotching out of the way
Right,
of things,
right.
managing to elude the falling cans.
Right.
So the injury is not prior injury is not necessarily a requirement, as I understand your answer, but I want to make sure that I'm clear on that. So long as there is some prior evidence of the actual breakage or things that could conceivably cause an injury.
Yeah, it's hard. And I know I understand that, hypotheticals is part of this, but I suppose under some circumstances, a court could decide that even if there's no specific injury of a product hurting someone, let's say it just misses somebody's feet on a regular basis or something,
Even if on a regular basis there's simply shards of glass on the floor, I think we could probably conclude that that's a hazardous condition. And that's the distinction I was trying to draw with liquid that people understand you slip on. Whether someone has actually slipped on it, that seems to be a hazardous condition.
It certainly can be if it's in a public area of the store, that kind of thing. I think in Contreras, the problem there was that, first of all, it didn't happen that regularly, that there was a spill. And second of all, there was no evidence of, was this happening in public places? There just wasn't enough evidence there to conclude that that a hazardous condition was regularly arising. And I think this case is even less susceptible to the mode of operation rule in Contreras.
Because while it's conceded that customers interfere with the packages all the time.
Yes.
Every night they have to pull stuff off that's been opened.
And do.
And if the packages, if a customer who picks up an open package could be hurt, but it just hadn't happened. That's the argument. Things weren't falling out.
And there
Right.
wasn't an obvious hazardous condition just looking at it.
Exactly. Ms. Schaefer testified she saw nothing wrong with the package, and that's, excuse me, I just need a little bit of water.
I'm talking more about the obvious to the store with
Right.
that hazardous conditions arise from the open package.
Right. There's no evidence that they could tell. Well, let's pick the air freshener section, for example. There was testimony by Mr. Ammon that there had been no similar issues in the air freshener section with products falling out. So there's simply, again, we come back to the idea of notice. If Ms. Schaefer's interpretation of the mode of operation rule is correct, I don't know when a retail store would ever escape liability where someone is injured because a customer has tampered with a package. I mean, if all it takes to get to the jury is just that customers open packages, that's true for any retail store. And where does the liability end? Chiara made clear that this is a limited application rule, and Ms. Schaefer's interpretation is the exact opposite of that.
What is the jury question if the plaintiff does get to the jury on a mode of operation rule?
Could Walgreens reasonably anticipate that a hazardous condition would regularly arise? And there's simply not enough evidence to put Walgreens on notice here. This is not one of the it's not a case where Walgreens is doing absolutely nothing to address this problem. Its mode of operation, yes, it's a self-service store. It's a store for the neighborhood, but it also checks those products every night. And under that mode of operation, where they're checking products every night at a minimum, and sometimes during the day, and taking them off the shelves when they see a problem, under that mode of operation, no product, and particularly not a heavy, sharp, breakable product, has ever fallen out and posed a hazard to customers. And so for that reason...
Mode of operation, it seems to be serving a different function. I'm not sure the fact that they take things off the shelves, it seems to me that may not necessarily be dispositive, even if they only check it once every week.
Mm-hmm.
I assume your view is that there has to be a hazardous condition that people can tell exists, like something has fallen,
Yes.
glass on the floor.
Absolutely.
So
Your Honor.
even if they only inspected it every three nights, it doesn't necessarily establish that the hazardous condition regularly arises.
That is true.
I take it there was no discovery taken or allowed of Walgreens nationwide on falling air freshener bottles.
I don't know the specifics of that, whether a discovery was sought or denied. Perhaps Mr. Smith can speak to that. What I do know is that Ms. Schaefer filed a Rule 56F motion to get more discovery. That was allowed, granted, and then the court, ruled on the motion for summary judgment. So Ms. Schaefer certainly had whatever discovery she thought she needed. Unless the court has any further questions. Oh, sorry.
Actually, I do, and Mr. Smith can respond to if you answer differently. The spoliation.
Yes, Your
issue,
Honor.
Is that only raised in the context of a jury instruction that should be given if the case goes to a jury?
I believe so, Your Honor. And as the trial court pointed out, well, first of all, there's no basis for a spoliation instruction. There's no evidence that Walgreens willfully or, destroyed evidence when it knew that this case was going to trial. There's just no evidence of that. But as the trial judge pointed out, even having the package would not fill in the gaps of proof in the plaintiff's case. everyone agrees that the package was open. But in having the package would not explain the how or why it was opened. It doesn't help the plaintiff get to the jury to have spoliation. And as you mentioned, there would only be an instruction if the plaintiff was able to get to the jury.
Because it's undisputed that it was open. So
Right.
It was open. Okay.
It was open. No one disputes that.
And it's undisputed that Ms. SHAFER didn't see it, that it was open when she picked it up.
That's correct.
Okay. Questions?
All right. Thank you, Your Honors.
Thanks all.
Here we go. I think that what we got to be a little careful of, and what Walgreens is trying to do, is basically take this case and say, it isn't that we have to know of an injury or release of breakage or something like that. It's undisputed their people testified this was a problem. It was a substantial problem. That problem caused a risk. That's what the method of operation requires. They can defend it in front of a jury, but that's what the method of operation requires.
What's your best statement or evidence that they said that a hazardous condition will regularly arise? Is there a
They said that
specific answer?
I'm sorry, Judge.
No, I'm just wondering, was there a specific answer to an interrogatory?
Yeah, all three of them testified. I did not ask that in an interrogatory. Now I'll answer your question about the discovery in a minute, Judge. I didn't forget you. We asked it at the deposition, did you know this condition arises? Yes. It's a substantial problem at this store, that they
problem
open
is the opening package.
products, and that those products are opened and put back, and they open top and bottom, and they're put back on the shelf every day. And what do you do to address that problem? Well, we take them off the shelf at night to recycle them in the bins. That's the evidence. If it takes a fall or breakage of that, that would allow someone to negligently run basically it does away, if it takes an injury or one of these things to fall and break before they have to correct it, that takes it back to the notice requirement. That's all. That does away with the mode of operation or the method of operation claim, because it means they have to have notice of a fall. Maybe not that specifically breakage, but they have to have notice of it. And what we tried to, and this kind of, let me tie back into the courts, we had difficulty getting Ms. Anderson was not the trial attorney. We had difficulty getting these people to be deposed. It took us basically over an order from the court to get these people deposed. And that was why the 56F was filed, to get those people deposed. Walgreens at first claimed that in this case that they did not have a record of this occurring, that they did not have an incident report. We later found out there is an incident report that was filed, but it's just there was an injury today, just that. It's nothing about this. Walgreens did not produce anything from this store or any other store or across the country showing that they had had this problem before in this matter. And requests for incident reports, rightfully so, concerning at this store was very limited.
Okay.
But that was your answer to that. Any other question? I got 24 seconds.
No, I think we're good.
Thank you, Your Honors.
Thank you to both counsel for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. And now we'll recess for a bit to allow the next case to set up.